Good morning, everyone. I'm Elena Popp, the Executive Director of the Eviction Defense Network. I'm going to ask everyone to please mute. We're going to go straight through the presentation, and then we're going to stop recording and ask questions, allow for some questions and answers at the end. I'm the Executive Director of the Eviction Defense Network. The Eviction Defense Network is a small 501c3 nonprofit in LA County. We have 9 lawyers, and we are at the forefront of stopping gentrification in LA County. We defend tenants in evictions in 4 courts: the downtown LA court, Pasadena, West Covina, and Compton courts. We are members of the Right to Counsel Coalition, which sponsors a program called Stay Housed LA. That is a coordinated effort to represent as many people in LA County in evictions. I'm going to ask everyone again to please mute themselves. And Kevin, since you're co-host, can you just go through and mute everyone who hasn't followed that instruction? So this is our presentation on the eviction process. We have other presentations, one on Tuesday evening in Spanish, one on Thursday evening in English, one on Saturday at 1 o'clock in English. And those presentations are about what protections tenants have during the COVID crisis and more general tenant rights. This presentation is about the eviction process itself. It is designed to get people to stop being so scared of the eviction process. Being in evictions is serious. It is stressful. It is time consuming, but sometimes it is the necessary next step if your landlord is harassing you, refusing your rent, falsely accusing you of violating your lease or of a nuisance, and your rent is affordable or lower than it would be on the open market, and you don't have other options, or if you simply want to stand up for yourself, defend your rights, because when tenants move out, when tenants give up, rents can go up to market, and that's how we're losing affordability in all of our communities. The eviction process starts with a notice. The number of days in the notice could be 3, 30, 60, 120, 15, any amount of days to do something, or sometimes it says quit, sometimes it says vacate, or other words that mean move out. And if you do not do what the notice says in the number of days that the notice asks you to do it in, the only thing the landlord can legally do is serve a summons and complaint for eviction. A summons is the paper that gives the court jurisdiction over the parties. The summons is what brings you or summonses you into the court process to file an answer and then participate in the rest of this process. Without a summons, the case can't move forward. At the beginning of the pandemic, the State Judicial Council and our Supreme Court Justice looked at, frankly, the inaction of our governor and said, hey, let's do something. And the analogy I've been using is our communities were a wounded patient bleeding out on the ground. We were in LA County, 500,000 households unable to pay the rent. And the governor looked at that and said, oh my God, I don't know what to do with that. Nurse, deal with it. Nurse being local government. I give you power to pass laws. So local governments like the County Board of Supervisors, the LA City Council and the mayor, and the local city councils and mayors of about 40 of the 88 cities in LA County passed protections. But these protections were really band-aids on a gaping wound.
¿Puede traducir en Spanish, please?
Okay.
No hablo inglés.
Ok. ¿Sabe que usted es la única que no habla inglés? ¿Por qué no hacemos esto? ¿Por qué no?
¿Puedo hablar después?
Sí, ¿por qué no me llama después de la presentación y hablo con usted? ¿Ok?
Sí, me puede dar su teléfono, por favor, espéreme.
Jayla,
Por favor. Estoy oyendo, pero pues no entiendo nada.
Un momentito. Jalen, can you give her the link to Tuesday? And so that she can come on Tuesday. Le vamos a dar el enlace para la presentación en español, ¿ok? So where was I? So the city councils then passed these band-aids, and the state Supreme Court said to local government and to the governor, hey, this is not doing it. And they came and they put a tourniquet on the wound. That tourniquet was something called Rule 1. It prohibited the issuance of a summons. So you could file a complaint, but the case couldn't move forward because there was no summons. That had the effect of lowering the number of legal eviction filings in LA County from 3,381 per month to 258 per month. And that held true between April, when Rule 1 was passed, and October, when it was lifted and replaced by a state law that was a weaker or a more loose tourniquet. And at that point, eviction filings went up to about 1,000 a month. So still better than 3,381, but a sharp increase from the protections provided by Rule 1. That's why this summons is so important. People are asking what's going to happen after September 1st. Well, after September 1st, in order to get a summons issued, the landlord is going to have to attest to certain things, including participation and cooperation with the rental assistance program. So for people who did not pay their rents between March and September, there is going to be some little added protection against you ending up in eviction court. But for people who cannot pay the rent in October, the only protections in place are what's available under your local city laws, or if you're in a city that does not have local protections, under the county protections. More details about that, 1 o'clock webinar in Spanish, Tuesday. So when I said the only thing the landlord can do legally is file a summons and complaint, what I mean by that is we're seeing a sharp increase in illegal evictions, 75% increase from pre-COVID numbers, and also a sharp increase in harassment, 352% increase in tenants reporting harassment. And we aren't keeping statistics on people self-evicting, but anecdotally, I can tell you that a lot of people give up. I have clients who are telling me, I just want to move, negotiate a move out. Okay, where you're going, what's your plan? Do you have a place to go? No, I just can't stand it here anymore. I literally had a client tell me when I asked him, where are you going? I'm pitching in a tent in the park 2 blocks down the street. I can't stand it here anymore. And I thought he was joking. Turns out he wasn't. Okay, so self-evicting is the result of landlords circumventing this process. The complaint is exactly that. It's what the landlord is complaining about. It's the landlord's side of the story. It's the landlord telling the court the tenant didn't pay the rent, or the tenant is a nuisance, or they're violating their lease, or whatever else their concern is against you. This summons and complaint packet is supposed to be handed to you. It's usually at least 15 pages long, often much longer. Sometimes they put exhibits and other attachments. So it is an obvious thing, and it's supposed to be handed to you. Many process servers just dump it at your door and hope you will just answer. And so if it's dumped at your door, my advice is just answer. It is way more complicated to fight about whether you were served properly than it is worth. You'll have 5 business days to answer. Then a bunch of stuff happens, and then a trial date gets set. But it's actually a misnomer, because neither side is ever ready to go on the first date of trial. We use it as a negotiation platform. We use it to figure out, well, how is this case going to shake out? Usually cases get continued multiple times because this is a high practice area of law for both sides. for both the defense side and the landlord side. So often one or the other side is not ready to go forward and needs a continuance. And sometimes both sides are ready to go forward, but there's not a judge available because there's only 33 judges doing trials in evictions. During the pandemic, there were often no judges available. So, and we weren't doing jury trials for the most part during the pandemic. A few were done, but most of them were just very difficult to get done. And jurors weren't showing up, and so we couldn't get enough jurors. So there's this wait period, but eventually there is a trial and then a judgment. And if the tenant loses, then the sheriff will post a notice to vacate, and within 5 days, sometimes 6, 7, 8, 9, 10, they'll come and lock you out. If you win, you get to remain as a tenant. If you don't answer, you go to this route a lot faster. So it's important to answer and fight. What's not on the diagram is negotiation. Throughout this process, there's an opportunity to negotiate. And what I want to make clear about this box is this is a tiny, tiny box. People come to court and they want justice. They want to tell their story to the judge. They want to have the judge compensate them for all the harassment and all the bad things that the landlord did to them. That does not happen in eviction court. If you want that, you have to file your own separate lawsuit. And unfortunately, there really are no lawyers that will file harassment cases. And there's two reasons. First, harassment is not that high value a type of law. So for the person that was asking about harassment during the introductions, mainly we talk about this in the 1 o'clock webinar, but harassment is no one is killed, no one is maimed, right? So it's not going to be $1 million case. And so lawyers are not that interested. We've just recently passed some tenant harassment ordinances, one in the city of LA, one in the county of LA. There's stronger penalties and protections at the state level that were passed during the pandemic. But the problem is that even if you can get some nice amount of money for the tenant and therefore the lawyer also gets paid, it's hard to collect. Why? Because these are not insured claims. Insurance protects negligent claims. You can't negligently harass someone. You're either harassing them or you're not harassing them. That's a deliberate act. And so it's not covered by insurance. Since it's not covered by insurance, it's hard to collect. When I was in private practice, I sued several small landlords over harassment, and most of them declared bankruptcy. And so now you're in line to collect your judgment with a lot of other creditors. And so it becomes it just is cost prohibitive to sue small landlords for harassment. We need a solution because the harassment is out of control. So we need to develop a solution, but you're not going to find it in eviction court. This is the same diagram of the eviction process. Again, evictions start with a notice. If you don't do what the notice says, summons and complaint get filed. You're going to get a courtesy notice from the court in LA County. And for those of you listening on YouTube, this is a presentation about California law and more specifically what happens in LA County. So you're going to get a courtesy notice from the court saying an eviction has been filed. When you get served the summons and complaint, you will have 5 working days to answer. That courtesy notice can come to you first, or it can come to you after you get the summons and complaint, depending on how on it the lawyer on the other side is. The court mails it to you. If the owner on the other side has a good process server and they find you, it could happen. You could get this notice before or after. Do not ignore this notice. There's one to you, one to any other person that is also being sued, and one to all unnamed occupants. So you're going to get at least 2. Sometimes people claim they didn't get the summons and complaint, and they also claim they didn't get the courtesy notice. That's hard for the judges to believe because it implies that the landlord stole the mail. And although we have seen cases where it was obvious the landlord stole the mail, cases where the landlord controls the mail, cases where that's not an open mailbox and someone saw that in the weeks prior to the sheriff putting a notice to vacate all the way down here, the landlord was around a lot. Maybe someone saw him going through the mailboxes. But those situations are relatively rare. It is hard to prove you did not get this courtesy notice. Don't avoid service of the summons and complaint. All that will do is put you on this fast track to the sheriff locking you out. Accept it, and then I'm going to tell you exactly where to go with it depending on where you live in LA County. You'll have 5 working days to answer. If you do nothing, you're on the fast track to a sheriff's notice. So you want to be on this route on the left. And we jump you straight to filing an answer. There are motions that you can file, a motion to quash service. If the process server just dumped it at your door, you don't have to answer. You can do a motion to quash, but it's extra paperwork for us. And there's no, all that happens is you show up in court and then you're served, or you're served before we even have a hearing. So we don't do it because it's a waste of time. I figured out a long time ago that in the amount of time it takes to do 4 motions to quash, we can retain one other person and take them all the way through up to preparation for the case to actually go to trial. So we don't do it. Same things with motions to strike and demurs. People will often, can you just get this dismissed? Can you do a motion to strike? The problem with motions to strike and demurs is that you file them and then the landlord gets 30 days to correct their errors. So all you did is buy a little bit more time so that the landlord can amend the complaint. It's not worth it. And the judges get annoyed because it bottles up the court a little bit. So in my career, I've done 2 demurs, and in both cases, we could not tell what the case was about. The tenant never got a notice before the eviction being filed, and no boxes were checked in the complaint. So we had to do a demur because we didn't know how to defend the case because we had no information. Twice in my career. And so we really jump you straight to an answer. After the answer is filed, we also serve discovery, meaning we ask them to answer every question that could possibly have to do with the case and give us every stitch of paper that is going to prove their case. And then they usually serve us with discovery, and we have to answer questions, and we have to give them all of our evidence. And the purpose of that is to make sure both sides know exactly what each has against on the other, so that you can make decisions about negotiation. After discovery, there will be a request by the landlord for a trial. We never ask for a trial because we're not in a hurry to get you into court. They're in a hurry to get into court so they can kick you out. And then there will be a notice of a hearing. Theoretically, the trial has to be held within 20 days of this request for the trial. But in fact, the courts are bottled up and it's taking many, many more months than 20 days. If the landlord wins, then the sheriff posts a notice to vacate on the door. There are some motions that you can do, especially if you plan to appeal, and then the sheriff evicts. If the tenant wins, the tenant stays. Again, we're in this tiny little box that is about staying. It's not about getting you justice or stopping the harassment or anything else. All along, you can negotiate. Negotiation can even happen after you've moved. We often, especially if we think we shouldn't have lost, we'll file an appeal. I mean, not after you've moved, after you've lost. We'll file an appeal, and often cases settle during the appeal process. A couple of years ago, I had a case where it was a very esoteric point in the law having to do with whether or not a single family home was actually a duplex because the owner had converted the attic into an apartment and never removed any of the stuff in the attic, just stopped renting it and removed the staircase leading to it. So all he had to do after winning is put the staircase back on, and there's still 2 units there. And the judge found in our favor that it was 2 units. The bank appealed. It was a post foreclosure case. We never got the issue resolved because during the appeal, the bank sold the property to my clients. And so we never got an answer to the question. And so this often happens in an appeal, okay? What you need to know is that the eviction process is long and it is complicated. And with a lawyer, tenancy success 98% of the time. And this is not a guarantee, but it does speak to the fact that the 11 legal services providers in LA County that are doing this work know what they are doing. Success at Eden is measured at either winning and you get to stay or reaching a favorable settlement. When folks come into our office, we ask them to choose a path. In the intake questionnaire, it is, what are your goals? Do you want to stay or do you want to go? And if you want to go, how much time do you need? We always work to get your rent forgiven. And we try to also get you some money. And we always make it a deal breaker that the record must be unconditionally sealed. A sealed record means nobody knows about the eviction. Eviction actions are sealed in California from the moment that they are filed, and they remain sealed if they are settled with an agreement to keep it sealed, or if the tenant wins, or if they are dismissed, or if anyone in the case gets dismissed. Sometimes people get upset when minors are sued. I always applaud when minors are sued because we get the minors dismissed, and then that means the file will stay sealed no matter what, because you can't seal as to one party and not another. So seal dismissals means a permanent seal. That means no one can look at it. That means no one, it can't go on your credit. It can't go on your rental history. That's a good thing. The only way that the record will unseal, there's two ways actually. One is if you lose within the first 60 days. So default judgments are bad because if you don't answer and you end up here going this route, does nothing, there's a request to enter default, the judgment is entered in favor of the landlord. Now, and if this happens within 60 days, now your record is unsealed. If you lose after the 60 days, theoretically it can unseal, but it generally doesn't because they have to go back into court and petition that it be unsealed, and usually they don't bother. So we ask you, do you want to stay? That's the road to the left, or do you want to go? And then we ask, we assess whether the path you've taken is realistic, okay? So if you are a member of a household being evicted from the family home, you have never paid rent and mommy and daddy have had it, and they want you out, you are not a tenant. You're a tenant at will, and you can be evicted on a 30-day notice to quit as a tenant at will. Questionable whether that can be done during the pandemic, because the law, neither the state or the local laws are very clear on that point, on whether a tenant at will is considered protected. We have been successful in keeping tenants at will in most cases, although some judges have disagreed with us. But that's someone that needs to be on the go road, either on the go road or family counseling road, right? You need to figure out a way to mend whatever has resulted in your family not wanting you there anymore. Same thing for people who have never paid any rent. Or right now I'm dealing with a young man who has lost his case, even though he did everything he was told to do by an attorney in another agency. And his situation is that he applied to be added as a subtenant on a lease. And the management company said, no, your credit's not good enough. We don't want you as a tenant. And the master tenant and he decided to move him in anyways. And they hid his presence from the management company very deliberately. And the master tenant then moved out of state, but continued to pay the rent, and they continued this charade that she was there. Then the management company found out, filed a lawsuit. The master tenant answered, and because he wasn't named in the complaint, he filed something called a prejudgment claim to bring himself into the litigation so he could defend it. Now, I don't know what lawyer told him to file a prejudgment claim. I would have told him, you don't have a case, move out, figure out a way to move out. Now, if you have no way to move out and you need time, okay, let's bring you in, but you need to be working towards moving out because you don't have a defense here. There's no way you've been hiding from the management company. There's no way they're going to accept you as a tenant. They rejected you before. Now you went around their backs. You think they're going to let you stay? No way are they going to let you stay. So, um, but the lawyer that was counseling him didn't tell him that you file a prejudgment claim to bring yourself into the case, and you also then have to, within 5 days, file an answer. He never filed an answer. So now he has a default judgment entered against him because he didn't file an answer. He wants me to set aside the default judgment. There's no way to do that because when you make the application to set aside the default judgment, you also have to submit an answer, and there's no defense to the case. So we're going to lose that application to set aside the default judgment. To him, it feels so fundamentally unfair because he did what this lawyer that was counseling him told him to do. So how is it he's getting suddenly losing automatically? But it is what it is. And he needs to be on this road, and he needs to be realistic about the amount of time we can get him. But he wants to be on this stay road and somehow thinks that the other side can be persuaded. We made the offer and they said no, and he wants more. So, yeah, there are times when a tenant wants something that's unrealistic and we achieve it. But for the most part, we're spot on the money on what we can get people because you're working with a law firm at EDN that has a lawyer that's been practicing since 1985 and did this work between 81 and 85 while she was in law school. That's a lot of years of experience. And every once in a while, a client proves me wrong. And every once in a while, a young buck coming out of law school wants to try something that I think is crazy and it works. So I try to keep an open mind, but I also ask you to respect those years of experience and be realistic if I say you're on the wrong road. Sometimes we have people that are jumping to this move out road that have no reason to be on the move out road. The rent is low, the case is winnable, they don't have any other place to go. And so then we try to talk to them about whether they've chosen the right road at the beginning. Okay. For the most part, my agency wants to keep people in their units for a couple of reasons. First, because if you haven't been looking around, then you don't know how hard it is going to be to find housing. It is going to be hard to find housing. People are getting very creative about where they're going to go. I have people who, I'm going to tell you a couple of stories because I think people learn from examples. So I have clients who were on this road, this stay road, but during the litigation, they decide that they want to go over here. So they're asking me we don't have all-terrain vehicles, so we're putting you in a Ford Pinto and trying to drive all the way across here. And that's not an easy thing to do, and we don't want you to do it. But we will do it if you have a good plan. My favorite story is this guy who I'd represented in several lawsuits. And every time he was tired of the harassment, he wanted to be on this road. And I just kept telling him, find an apartment and then you can be on that road. But until you have a place to go, how can we say you're going to be out in 2 months or 4 months, given your income and this market? So I would always talk him into staying on this road. He was in court with one of my staff, and she calls me and she goes, okay, at my office, if you're going to give up a unit that's more than $300 below market, I have to approve it. I want to make sure it's not being done out of fear or fatigue, litigation fatigue. The client's tired, or the lawyer is scared about going to trial, right? We don't have the same lawyer who's negotiating is usually not your trial attorney, because I don't want the pressure of I'm going to trial to have any bearing on the decision to settle. And I have to approve anything that is giving up a unit more than 300% below market or below. So she calls me and she goes, this guy is telling me not to call you because he's afraid you're going to talk him out of this deal. And what's his plan? And he goes, he wants to tell you his plan. So he gets on the phone and he says, okay, I have a plan this time. Okay, what's the plan? My friend moved to Thailand, has an extra room, and I can live in Thailand for $300 a month. And I'll have between what they're offering, which I think was $75,000, and my SSI, I'll be living in luxury in Thailand with my friend And that's what I want to do. Now that's a plan. It's an unusual plan, but it's a plan. I have several clients right now that are planning to move to Mexico with the money that we're going to get them. I have clients who have moved to Utah and bought property in Utah, Arizona, Riverside, Barstow. So if you are willing to take what we get you and move out of LA, that's a plan. But you need to have a plan if you're going to be on this move out road. Okay. If you're going to, I'm sorry, on the right, on this move out road. And if we're going to be on the stay road, we have to have good defenses. Okay. People ask me, so how much time can you get us? Right now, we're getting people a lot of time. Generally, we can't get you more than 4 months from the date that we're signing in a settlement, but we've gotten more than 4 months. But usually 4 months is sort of um, uh, the outside of the envelope. A couple of years ago, I tried an experiment where I would offer at the beginning, a client who knows they want to move, this is a during the better housing market when people could really stay in their same neighborhood or at least in the city if they moved out. We started offering 6 months and a forgiveness of the rent, 4 months and a forgiveness of the rent at the beginning with the answer. And the plaintiffs can't fathom it, even though by the time we get to court and they accept it, we've ended up with 8 months and a forgiveness of the rent. Because at the time, the sort of standard was 2 months from date of signing. Right now, we're getting a lot of people 4 months from date of signing who want to move. Okay, so to repeat, you choose a road. That road has to work for you, right? Meaning, we aren't negotiating people into homelessness. So we need to know that you have a plan for where you're going to go or what you're going to do. And and if you're staying, we need to have a winnable case. All right. So in determining whether a case is winnable, we look at 16 factors. The first is the value of I'm sorry, not in determining whether it's winnable, but in determining what to do, what the client's right road is. We start by looking at the value of the unit. And so are you in a below market rate unit? Is that unit protected by a rent stabilization law? There is rent stabilization in 9 cities in LA County. And if you're not covered by one of those laws, you might be covered by the State Tenant Protection Act, which covers any unit in the state of California built more than 15 years ago. So it has to be at least 15 years old. And it exempts single family homes and condominiums, unless the single family home or condominium is owned by a corporation. And it exempts the second unit in a duplex if the owner occupies the first. Otherwise, you should be protected. It also exempts student housing at universities, board and care facilities, co-ops, nonprofit housing, etc. But most tenants in California are covered by the Tenant Protection Act if they're not covered by a local rent stabilization law. So we need to know the law and if you're protected. Also, if you're covered by a subsidy, public housing, subsidized housing, or Section 8, those are protections, and therefore we want to save those units. So how below market is the unit, and is the unit protected? The next thing we look at is, can we win? Do we have a defense to this eviction? Do we have evidence to prove the defense? Do we have witnesses to prove the defense? Are they going to be good witnesses? And how likable is the client? And a lot of clients get upset with me because I am very upfront. And if you don't want an upfront lawyer, you do not want to work with me. I am a tough love gal. In Spanish, we say, no tengo pelos en la lengua. I don't have any filters. So I'm going to tell you exactly how I see it. and it is to your benefit. And if you think that that's rude or condescending, then you don't want me as a lawyer. Because it's not rude or condescending. It is being upfront and honest and telling you how it is. And I'm not going to paint it with rose-colored glasses because that doesn't benefit you. You need to know exactly what's going on. And one of the things that tenants do when they're talking about their case is, because it is a horrible and stressful situation, they are either angry about it and they're barking about it and they're saying and they're talking with this tone when they're telling it to me. And honestly, this is extremely, extremely stressful to listen to people all day long talking with this tone. And it doesn't benefit you, because if you go to court and you testify like this, you will be unlikable. And anything that is a wobbler, that is at all questionable, will be cited against you. And you could have said everything I just said with this tone, right? But it takes some practice. This is not my natural tone either. And sometimes I with clients, but this is the tone I strive for when I am in court, because this is pleasant. If I talk like this, you can hear me. You can be a little emphatic, like the way that I present is a little emphatic, but it's never barky, right? It's not this tone unless you piss me off. And sometimes clients do piss me off when they don't follow my instructions and get themselves into trouble. But don't use this tone, not to me, not when we're practicing, not to other people, and not when you're testifying, because this tone is much better. So I hope people can catch the difference. And it takes practice to talk like this. This very, very pleasant tone. The other tendency, if people are not barking about their situations, for people to whine about their situation. And I'm not that good at doing the whiny voice because I'm not generally a whiny girl. But you know, the yeah, 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 and then the yeah, 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 and it is unpleasant. And so again, you're not likable, and therefore anything that is at all sort of a 50-50 kind of thing will be decided against you. So you need to practice this tone, this very, very level tone. You also need to learn how to tell a story in a correct order, right? Um, People tell stories without giving a date. Start with on X date at X time, X happened, and then tell the story chronologically. All right. And when you're testifying, you need to tell a story in a way that is unnatural. You need to listen to the question, answer only the question. So if you are asked, do you know what color the sky is right now? The answer is not blue, gray, or cloudy. The answer is yes or no. And if we care to know what color you think the sky is, we will ask you the next question, which is, what color is the sky? And then you will answer blue. And if we're inside, we might ask you, on what do you base your statement that the color of the sky right now is blue? And you might say, well, it was blue when I came in. And then the opponent might say, you actually don't know what color the sky is right now, do you? Because you've been inside for at least 4 hours and the color could have changed. And now you're a liar. Okay. So you have to be very, very careful. And we practice this before your trial. You have to be careful to listen to the question, answer the question, answer only the question, in a very level tone, not whiny, not barky, and be able to back up your answer. Okay, think it through so that you can back up your answer. Okay, so that's can we win? Then we look at other leverage. For instance, if I have a client that I know is going to move because they have a job in Utah and they have a place to go already in Utah and they just need 4 months to move out, what I can do is send an answer with discovery and a jury demand. When we do a case in front of a judge, it is a lot faster because the judge doesn't need to be educated on the law. So when we do a case in front of a judge, you show up, usually the case happens that day, maybe one continuance. It takes at most a day to do. Usually less. I have a judge in Santa Monica that boasts that she can do a eviction trial in 10 minutes. That also is illustrative of how fair she is to tenants. You cannot do a fair bench trial in 10 minutes. But it is a lot faster with a judge and therefore cheaper to the landlord. It's also, the results are atrocious for the tenant for the most part. But when you do a jury trial, minimum you're going to spend, once the case is assigned to a judge, 3 to 5 days, sometimes more. So therefore, it's more costly to the landlord. So if I send an answer with a jury demand and a whole bunch of questions to answer in discovery, that's also something they have to pay their landlord, and an offer that you'll be out in 6 months. If a landlord takes the two business brain cells the goddesses gave them, rub them together, they will say yes to that offer. There might be some back and forth, but they should be accepting that offer because we're going to be litigating for 8 months anyways. So you may as well save that time, energy, and trouble and money, and accept this offer. Lawyers are mandated to bring every offer to their clients, but a lot of our opponents won't take those kinds of offers to their clients unless they're in writing. And so we have to make sure that the offer has been given to the landlord by putting it in writing. And then that leverage will get us what you want. But if, and pre 2016, this housing crisis that we're in started in May of 2016. But pre 2016, our clients often were happy to just move someplace else. They already have some hassles with the landlord. There really is no point in them staying. They can find another unit comparable for comparable price. And so we often would settle cases early in the litigation if the tenant was willing to move. Because first of the rising prices starting in May of 2016, then the pandemic, we really can't make these kinds of settlements unless people are moving out of state and they really know when they're moving and they have a plan. Because if we make an offer, even a 6 month offer, because you're sure you're going to be able to get out in 6 months, there's been so much unpredictability in the housing market, and landlords don't want to rent to people unless you can show a stable job without interruption. That's at least twice the rent, and some are asking for three. I had a landlord asking for 6 times the rent and income. It's like, good luck renting that unit, dude. Um, but um, but landlords are asking for a lot because they don't want to move you in and then have you say, I'm COVID impacted, and now they are collecting rent. So so it's been very hard for tenants to find. So we're not making these kinds of deals very often. But these things are both necessary to prepare the case. Discovery is necessary because that's how we know what they have against you. A jury demand is necessary, honestly, because most judges come from affluent families. They can't relate to tenants. If they were ever tenants, it was when mommy and daddy were paying the rent when they were in college. And so we need people deciding your fate that can relate to you, a jury of your peers. And so that's why we do the jury demand. But there are good judges that are fair. And if we draw one of those judges, we will consider waiving the jury. Another leverage point is unlimited attorney's fees. If you look at your lease agreement, towards the end of it, there should be a provision that says attorney's fees. If an eviction is filed or if a lawsuit is filed, it usually says the prevailing party shall be compensated their attorney's fees at a reasonable rate. The prevailing party is the winner. And if it's unlimited, then that's a huge leverage point for us, because if they fight and we win, we could recover 20, 30, 40, 50, $60,000 in attorney's fees. That's a huge leverage point that will usually result in a settlement because the other side is afraid of those attorney's fees. Now we have to be afraid of it too. This is a double-edged sword, because if you lose, you're going to owe those attorney's fees. But the blade is sharper on our side. But you have to keep reminding us whether or not you are collectible. We are very used to working with people who are very low income, chronically low income, and the debt will never get collected because they don't have the money to pay. But right now, during the pandemic, we're representing a lot of people who are not chronically low income. They are usually upper middle to or higher, currently low income. Well, you're not going to stay in this category forever. You're going to recoup. because your education or business sense or whatever it is, your industry will go back to being what your industry is, and you will recoup, and then you're going to be collectible. So you don't want a $60,000 attorney's fees judgment hanging around your neck, right? And so so that becomes the knife a little sharper on their edge if you're that kind of a tenant. Okay. The other thing we consider are, again, and this is on the same theme, client finances. If you are on disability, on government benefits, SSI, not garnishable. They can't take that money. And so if they're not giving us a good offer, yeah, if we lose an eviction could go on your record, but they'll never collect the money. And so we have some leverage there to get you the rent waived. But if you are affluent, get a regular paycheck. I used to, when I was in private practice, represent a lot of people in the entertainment industry. People in the entertainment industry are feast and famine people. They get a gig, they paid a lot of money, they get a luxury apartment, and then things dry up for them, and suddenly they find themselves in eviction proceedings. And so they don't have any money, but that's not usually going to be the case forever. And so we can't get the rent waived because they know they're going to be able to collect from you eventually. And so we have to keep that in mind. So client finances. If you are a single mother on welfare, that's not collectible. Again, we're likely to get the rent waived. And if you are a day laborer without a social security number and a common name, they're not going to, Juan Ramirez has a lot of evictions on his record already, so it doesn't really matter. And so we're going to be able to get that rent waived. So we have to keep that in mind as we're negotiating. The next box is, what are you risking? What's on the table? What have they offered? So I always tell my young trainees that that negotiation is a combination of playing poker, chicken, and let's make a deal. Poker, chicken, that's the game where the two cars are going towards each other, who's going to deviate first to avoid the crash, and let's make a deal. I also have my young trainees watch the scene from Point Break where they jump out of the airplane, and Patrick Swayze has jumped out of the airplane, has a parachute. Keanu Reeves has a gun, no parachute, jumps out of the airplane, catches them midair, and then they do the negotiation of a lifetime, right? With Keanu saying, pull the chute, and Patrick saying, no way, if I pull the chute, then you're going to arrest me when we get on the ground. You have to drop the gun so that you don't have a gun to arrest me when we're on the ground. Pull the chute, drop the gun, pull the chute, drop the gun, negotiating until the point of last return, and Keanu pulls the chute. Okay, you have to decide whether you're Keanu Reeves or Patrick Swayze in a negotiation. And if you're Patrick Swayze, then we're all going to be, I think they say, meatball pizza, or we're all going to splat on the ground, right? I'm Keanu. If I don't think I can win, I will recommend that we pull the chute, but I often do it at the last minute to get the best deal for my client. I recently had a case, for instance, in Pasadena, based on the unit is protected by the Tenant Protection Act. She was being evicted for substantial renovation. They were alleging that it was an emergency, but they didn't have the evidence for that, and there's no way they would have won the case. No way they would have won the case. There are no guarantees, so I would have put it at a 99% in our favor. I thought we could win the case. But as soon as the pandemic is over, they're going to be able to serve her that notice and get her out. And when the pandemic is over and they serve her that notice, she's going to be entitled to 1 month of relocation. And so what my client had to think about is the pandemic going to end? Are the protections going to end at the end of the month? Yes or no? In Pasadena, there's no end date. So she could have held out to see what the Pasadena City Council is going to do. But they offered her the offer she had made before they even filed the complaint. And it was an offer. she has a place to go at that point, plus $25,000 and all the rent forgiven. But we were literally pull the chute, drop the gun, pull the chute, drop the gun. Except in this case, I knew that there was a cushion we were going to fall on because I thought we were going to win. And at the very, I'm talking, the jury is lined up in the hallway. We kept our offer on the table the entire time, never budged from it. And at the last minute, opposing counsel leans over, and I said, "That is not social distancing. Don't lean over towards me." And then gives me two thumbs up and winks at me. And I'm like, "I really think you need to use your words. What does that mean? We accept your offer." So then we wrote it up, and the tenant was happy and the landlord less happy, but the case got settled. Okay. So that's the, I have a client right now who is being offered $75,000 to give up a unit that's in the $400 range, rent controlled in LA. That's not enough money to give up that unit, but she also has a case that we can't win. Accused violation, she was in violation, she didn't cure within the 3 days. I think we lose that case. We might win a hardship motion. And when they weren't offer anything, I'm like, let's just see if we win the hardship motion. There's no point in not trying. But now we're weighing that against 75,000. And that's a lot to be risking. And honestly, I've been telling this story for at least, I don't know, 6 months. And that case keeps getting continued, because the other side is not so sure that they want to take their chances. Probably they think I have something up my sleeve, because I often do have something up my sleeve. But mainly what I have up my sleeve is the hardship motion. So you have to consider what is on the table that you are risking. If a tenant has a Section 8 voucher, we used to be very adamant about not risking the voucher and putting people with Section 8 vouchers on a move out route immediately. But now it's so hard to find a Section 8 unit that we have to fight those as well. In figuring out how all these factors work, we also have to consider the current circumstances. So for instance, time to move and forgiveness of rent used to be very easy to do, like 2 months and a waiver, very easy deal to make. Now, 4 months and a waiver, 2 months and a waiver, even 1 month and a waiver is a harder deal to make because that waiver is $25,000, $50,000. Sometimes that waiver is so big that the landlord won't waive the rent. So now we're doing a lot of apply for the rental assistance and then figure out either whether it's a pay and stay or something else, right? So you have to be looking at your circumstances as well. I'll tell you another story. I once settled a case for 3 weeks to move, payment of all the rent, and a clean record. Why? Because we couldn't win. This was a young man who was a financial counselor, not mortgage broker, but people that advise people about stocks. He had lost a job, gotten into trouble, went through his savings, got into trouble, got into eviction proceedings, and had not one thing wrong with his unit, not one thing, because it was a luxury unit, right, in Marina Del Rey. So not even a loose light switch cover, right? Nothing wrong with the unit. So there was no way to win that case. And he had already gotten a new job. He was going to land on his feet. And he needed, what he needed was a clean record more than anything else, because an eviction on his record would have ruined his career. So that was a good deal. You have to look at all of the circumstances in deciding how to settle a case. And then you want to look at the players. You want to look at who's our opponent, how good a lawyer are they. Look at the landlord. Park La Brea Management is a good example of this. Park La Brea Management will not waive rent, period. If they have a case they can't win because they made some technical defense, they will dismiss or cancel the case, dismiss the case, and then start all over, even though they know it means another 4, 5, 6 months of not of the tenant not paying the rent, which they will then have to move to collect, but they will not waive rent. And I had a woman, I'm in court, I'm waiting for my case to be called, and this woman kept looking at me kind of sheepishly and then looking away, and she looked vaguely familiar, and I finally went up to her and said, "Hi, it seems like you want to say something to me." And she goes, "Yeah, I'm here, and I'm just a little embarrassed." And it turns out that the story was that she was being represented by a different agency, a member of the Right to Counsel Coalition, an agency that has good lawyers but slightly different philosophy on how to do this, and that I had interviewed her, and that I had interviewed her, and she had decided to go with them instead. So she was embarrassed by that, and she'd been watching me operate the hall, for a while, and she was second doubt, second thought, thinking herself about whether she should have hired us. And I said, "Well, why didn't you hire us?" She goes, "Well, you were such a Debbie Downer." Um, I wasn't being a Debbie Downer. I was just telling her the truth. And the truth is, you have no defenses. It's part of La Brea management. They're not going to forgive the rent. The best you're going to be able to do is negotiate a reasonable amount of time to move, clean record, and a payment plan. The other firm had told her, "We'll make them pay you money." Ultimately, she came back 2 days later with a judgment against her, right? Because no amount of, if you've got a dead bang loser in Park La Brea, no amount of "we're going to take it to trial" and blustering and pounding on your chest is going to result in anything other than the tenant losing. She wanted me to do something to help her. At that point, it was too late. There was nothing that could be done at that point because she had no bargaining power. So you need to know your landlord. You also need to know your judge. So the way this happens is where all cases are assigned to what are called calendaring courts. Well, actually, this is now a little different. Things keep changing for us. In LA County, if your case is downtown, you're assigned to one of 4 courts, and that is likely to be your trial judge. Every once in a while, they're sending cases out to other judges, but it's most likely that's likely to be your trial judge. And all 4 judges are acceptable to our side of the bar. And one of them is not acceptable to the landlords because they think she's too pro-tenant. Although she's actually, I think she's fair. So 4 judges. If you're in any other court, the case doesn't stay in that court because the judges don't have the resources, the time to do the trials, and because most of those are commissioners, not judges, so we don't have to keep them, and we don't like most of the commissioners in the system, so we don't think they're fair to tenants, frankly. So we don't agree to them, and then we get assigned to another judge. And so um, we won't know your judge until we're actually assigned. But once we have the judge, sometimes we'll decide this is a good settlement judge. Let's see if I can settle it. Or this is a judge that will make a better decision. Like, for instance, the judge in Pomona is more fair to tenants, and jurors in Pomona tend to be more conservative because they're mainly homeowners. So generally, if we get assigned to the Pomona judge, we will waive the jury. So then we also want to look at our jury pool. Jurors in downtown LA will tend to be more pro-tenant, will tend to be mainly tenants. Jurors in communities that are mainly homeowners will tend to be more either neutral or not sympathetic to tenants. And then we look at our own lawyers' skill sets. At Eden, we make sure that our younger lawyers are second chaired until they are ready to do trials. While this is not a guarantee, a lawyer on my team has just won 5 impossible cases in a row, including 2 that I told her I thought she needed to settle because I didn't see how a jury would find that what the tenant had done was not a nuisance. And she won both of those cases. So you need to, so if you're with Eden, you're going to have a good lawyer. And then you need to look at yourself. How risk adverse that are you? I'm working with a 22 unit, it's a 60 unit building, 22 tenants in eviction proceedings. And I'm having a meeting with them last Sunday night, trying to decide whether they're going to take an offer. And one of the young couples basically, I mean, they couldn't decide and they couldn't decide. And so the situation for them is there's a reasonable offer, not great, but they can go back and live with their parents. So they have a place to go in the amount of time that's being offered with a complete waiver of rent and some money, not a huge amount of money, but some money. And so, but we have a whole other affirmative case going on, and we're about to sue the landlord on another set of stuff. So we could end up with a way better result than this offer. But the question for them are you the kind of person that walks into a Las Vegas casino, puts down $1,000 on the roulette wheel or not, right? And they're not. So they took the deal. But if you're a gambler, I think people that are gambling are probably going to do better than that offer. And I could be wrong. And if I'm wrong, it's going to be a really, you know, a detrimental. So you need to know how you are, your whole circumstance, your personality. Do you want to take the chance, etc. And then we
Excuse
all
me.
hold on. We're recording, so I would rather you wait. And then we always go back to can we win? Okay. The person who wants to talk, we are recording this. So my preference would be that you wait until we get to Q&A. Okay. Uh,
Okay, so
all right. So, so going back a little bit, evictions start with a notice. That's, I've already shown this diagram. It gives you X number of days to do X, and those notices take many shapes and forms. These are the most common. Pay or quit, usually minimum 3 days required. Right now it's 15 under COVID. Cure or quit, meaning stop violating your contract or quit, minimum 3 days. Could be more days. Quit for nuisance. You've done something so horrible that you can't ever fix it. So minimum 3 days. Quit no cause, meaning you don't have any rent stabilization protection. I can evict you and I'm going to do it on 30 days notice because you've been there less than a year. If you've been there a year or more, 60 days is required. Quit for no fault. This happens if you are in a rent stabilized unit. And so they have to have a reason to evict you. And there are fault reasons, not paying the rent, violating the lease, being a nuisance, violating a law, etc. But there are also no fault reasons. It's not the tenant's fault that the landlord wants to move in themselves or a relative. It's not the tenant's fault that the landlord wants to take all the units off the market or demolish, build something else, convert to condominiums. That's what we call the no fault reason. To terminate a tenancy that has a Section 8 voucher, minimum 90 days. If you're in a rent controlled jurisdiction and the landlord wants to take all of the units off the rental housing market, minimum 120 days. And if you're disabled or elderly, you can get a 1-year extension. And we also have to be aware of the self-terminating lease. You're under a lease, you're in the first period of the lease, say a year. And there's a paragraph that says, this lease terminates at the end of a year unless we take money from you. They don't have to give you a notice. The lease is simply self-terminating. Okay. These are the jurisdictions in LA County that have rent stabilization laws. So this is the state of California. This is LA County within the state. This is LA County. LA County has a whole bunch of areas. That's the white or blank spaces that are unincorporated, meaning they're not developed into any kind of a city. And note these little tiny bits, right? So sometimes people will say they live in a city, what they really don't, because they live in one of these little holes. And if you live in any of these white areas, you might be protected by the rent stabilization law in unincorporated LA County. Also, Baldwin Park, Beverly Hills, Culver City, Inglewood, Los Angeles, Santa Monica, and West Hollywood have their own laws. The red is LA, The other gray areas are all of these other 88 cities within the county, including these that have their own rent stabilization laws. Glendale has an eviction protection law only, but it doesn't have any rent controls. And so in order to evict you, all they have to do is raise the rent to market and then evict you for non-payment of rent. So this is not a very strong law, but at least it's something. If none of these laws apply, then we look at whether you're protected by the State Tenant Protection Act, which covers any unit that is at least 15 years old, does not protect single-family homes or condos unless corporate owned, and does not protect duplexes if the owner lives in the second unit. Okay, so these laws existed pre-COVID. I think there was just a rent control vote in Santa Ana, which is not in LA County. So we are getting more laws, and that's rent stabilization. In addition, we want to look whether any of these laws protect you. So the state laws, which are AB 3088, SB 91, and AB 832, which hasn't been added here, but you know there's a state law. These three laws work with each other. Is there any local protection in your city? Does your city have a law? And if it doesn't, then you're protected by the county law. And if your city law is weaker than the county law, then you're protected by the county law. We had for a while an order from the CDC that got taken away by the Supreme Court. So we look at all of those factors to determine whether the notice that you are getting, and these are examples of notices, not expecting you to read it. The point of this slide is they take many shapes. They look many different ways. They have to be written. They don't have to be signed. They don't require an official stamp. They can be taken from the internet. They just took this off the internet. Well, that's where they take them. That's where they get their notices. It just has to have required language. And if it doesn't have the required language, that's a defense to the eviction. Eden does not advise landlords on defects in their notices. We don't call the landlord and say, hey, your notice is defective, you're going to lose. Why? Because then they'll just issue one that doesn't have the defect, and then we're going to go to court without a defense. So we use the defects as a defense in court to either win or get you the deal you want. It has to be delivered to you and handed in your hand, and if you're not there, they can hand it to another occupant and mail it, or they can post it on the door and mail it by regular mail, or they can come to your place of business to give it to you. People feel harassed by notices, and we do have tenant harassment ordinances now that try to get at how harassing it can be to get one notice after another. Several years ago, I represented an elderly woman in a below market rent controlled unit whose landlord tried to get her out by lying to her that his daughter was going to move in. She didn't buy it, and so she didn't move out. And he started harassing her. He filed 6 lawsuits accusing her of not paying the rent, even though she had paid. And on the day of trial, all 6 times he dismissed when they arrived in court. But she was paying a lawyer each time, and she was running out of money. And then he started doing other things like taking away her washer and dryer, which he can do as long as he reduces the rent, which he did. But she was too disabled to go to a laundromat, so it was a huge burden to her, and the compensation wasn't enough. He stopped making repairs, which is a form of harassment. This was a duplex with a common area backyard and shared garage. She had always been allowed to let her dog roam in the common area backyard. Suddenly that was against the rules. And he could do that because under the law, you can't let a dog roam around free in a common area backyard. That's a violation of other laws. So there was a parking. He took away her parking. Again, disabled, parking on the street was not something she could do readily. He installed security cameras. So all of this stuff is going on, right? So while all of that harassment is harassment and actionable, the service of a notice is actually protected by the litigation privilege. And so when tenants think they're being harassed because they're getting notices, we have to look at that very carefully because that's something that's a protected activity for the landlord. They sent me so many notices. Well, if it's many copies of the same notice, don't be harassed. Don't feel harassed by that. That's actually a due process requirement to make sure you get it. Has to be handed to each adult. So if there's 4 adults, that's 4 right there. And if none of you are home, it can be left and then mailed. So now we're at 8, right? And so, God, I got 8 copies of it. They're harassing me. No, they're just trying to make sure they're following the law to make sure you get it. They posted it on the door, all open. Now my neighbors all know my business. It's an invasion of my privacy. It's actually a requirement of the law. It's supposed to be posted. They brought it to my place of business. Interestingly, the law says they're supposed to try to serve you at your place of business. Very few landlords do. And when they do, it's because they want to embarrass you. So, but it isn't harassment because the law says they're supposed to try. Okay. So this is an example of a 3-day notice to pay rent or quit. 2, list all the adults, and then all others in possession. Sometimes it says all unnamed occupants. That's who this applies to. Pursuant to your lease, you owe us this amount of money. It has to be exactly right, representing rent due from what period. Interestingly, during COVID, they have to get the months right, but pre-COVID, they could get the months wrong as long as the amount was right. And then it says, if you don't pay in 3 days, we want you to quit or move out, deliver possession to the landlord, or we'll start an unlawful detainer action against you and declare your lease forfeited. This is all essential language. If any of it is missing, the notice is defective and we can win. The same thing with this electing to forfeit your lease, meaning if we win, you don't get to be there anymore. If this forfeiture language is not there, if we lose, you can just pay your rent and stay. And then they have to say the date, who the landlord's agent is, the name of the human being to pay, the address, the phone number, and the times of operation. This one's defective. I think this one is missing where to pay, etc. This one is defective. It doesn't have the forfeiture language. And this is a sample of the declaration. We are asking everyone who hasn't been able to pay any of these months to send. If you haven't done it before, you should just do it now. Mark any months you haven't paid and then send it. If you get a notice to pay rent or quit, we're going to put you into a webinar. We used to do it in person. Now we're doing on the internet. We're going to explain all the laws to you, and we're going to tell you how to get help. During the pandemic, the only place to get help is at the webinars. You come, you listen. I've already been to a webinar. Well, then why are you asking me a question that got answered at the webinar? Come multiple times. People don't understand how much pressure we're under. There's 500,000 of you needing help at least. There's about 60 lawyers to help 500,000 people. If I can put 40 of you into a presentation and say it once, that is time efficient and way more efficient than saying it 45 times. So come to the webinars. At the Saturday webinar, there is one-on-one counseling by me. At the Tuesday webinar, there is one-on-one counseling by members of my staff. At the Thursday webinar, we're trying to figure it out because nobody wants to do Thursday. And honestly, Thursday is date night. I am married to the most understanding person on the planet. I work 12 to 19-hour days, and my spouse supports me, including me bringing me food for breakfast, lunch, and dinner at my desk so I don't have to stop to take a break. But Thursday nights and Sundays are sacred. And I can't find someone to do the counseling. So for Thursday nights, people are being sent to my office hours on Mondays, Wednesdays, and Fridays. So you can get individual counseling on Monday, Tuesday, Wednesday, Friday, and Saturday, 5 days a week, as long as you're patient enough to wait in the waiting room until we can get to you. And if you're in a non-payment of rent situation, you don't even have to wait for the counseling because really the questions are answered in the presentation if you are paying attention. At the 1 o'clock, we go over this chart that explains what to do if you were not able to pay your rent between March and August. 2020 and between September and September 2020. And what's going to happen in September, we go through these steps, we explain the local laws, we explain all of this, okay? And then you have the one-on-one chats. The cure or quit. This is a little tougher because we can't really go over all the possibilities of cure or quit during the presentation. And because often when the cure part is get rid of that dog you've had for 10 years, that's not a lightweight decision to do. Even if you've only had that puppy for a month, it's not a lightweight decision to make, right? Or ask your mother who's been evicted and is staying with you to move in 3 days. Those are not easy issues in a night, but the notice looks like this. Again, you list all the adults, any other in possession, the address, the part of the lease you're violating, how you're violating and how you can cure it, the witnesses and dates that they saw you, and again, all of that, give up possession and the forfeiture language. Honestly, in cure or quit situations, I think we should be assigning lawyers to people, but we don't have lawyers to assign, so we're doing the same thing. It's the webinars for now. We used to do it in person. Someday, I hope to go back to doing it in person because this is very hard for people with digital divide issues. We explain the state laws, we explain all your protections, and there is a one-on-one, and we tell you where to get legal help once an eviction is filed. For the quit nuisance, it's 3 days. There's no time to even do anything about it. This is an example. It's telling you exactly how you committed a nuisance. Again, it's the webinars. We explain the law to you. Um, you know, should we call to try to stop the UD filing? Generally, it doesn't work. But sometimes people want to do that, but honestly, it's better just to get into the case. Lay advocates, including solidarity caseworkers and clients, often will write these apologetic letters. I am so sorry that I did XYZ. That's a confession. Now they don't have to prove the case. Please avoid that, okay? Avoid confessing. Make them prove the case. Quit, no cause. It's usually that 30-day notice or 60-day notice to quit because you don't have rent stabilization protection. This is what it looks like. It's very much like the other ones, except it has to have this language about the return of your personal property. If that language is not there, you win. Same notice, but with the 60 days, you get this one does not have that return of property language. This one doesn't have hardly anything. It's totally defective. If you get one of these notices, it's because you don't have any protections under rent stabilization law. Right now in LA County, this type of notice is prohibited until after the pandemic ends. And then at the end of September, we're going to lose the protections statewide and LA County unless they get extended but we'll still have protections in some cities. So we will need to know what city you are in to know if you are protected still against a no cause eviction. 60-day notice is no cause. Again, you're in this situation, you are, I'm sorry, these are prohibited by these laws, okay? And again, at the presentation, we give the general information and then you can have a one-on-one. Then there is the terminate the Section 8. This is the one exception. We will retain someone at the notice stage if they're in a rent stabilized unit because we can negotiate that notice away and it won't come back once we tell them their error because in a rent controlled unit, you can terminate the subsidy, but then you're stuck with the tenant at whatever their 30% of the share is of the rent is. And so we will assign a lawyer that will talk to you on the internet, or I need to figure out how to put masks on these two lovely people so they can come in person. And then the Ellis Act notice is another one where we will assign a lawyer. Because often the landlord is bluffing. And because the tenants are eligible for 1 year extension, we want to make sure it's done right. And because we will work with the tenants to try to organize to save the unit or to look at purchase opportunities. And so it is really about organizing with the help of a lawyer, with the help of a lawyer, and in order to save the whole building. As I said, Eden is part of the Right to Counsel Coalition. We formed in 2018, or was, yeah, 2018, to fight for a statutory right to counsel, much like people in criminal cases have a right to a public defender. That requires both a statute that mandates it and money to pay for it. We were in negotiations with the city and the county of Los Angeles to start a pilot project in 3 zip codes when COVID hit. The project was then expanded so that we would represent people in the entire county. Um, it was expanded to the entire county without an expansion in funds. Honestly, until recently, I could boast that we had not turned away anybody in any of the courts that we handle, except one person who was asking for help with a trial that was 2 days later, and we were already in too many courts. This week, for the first time, we turned someone away in Pasadena because we have met our deliverables under all these grants through September. And we got so many cases all at once that we couldn't fit that other person in. And we're trying to get somebody else to do it. So it seems as though we're getting saturated. But I'm still going to say that to get help from the Eviction Defense Network, if your cases are downtown Pasadena, West Covina, or Compton, and for Compton, you have to be in the Compton court, but City of Los Angeles case, you can go to edn.la. You fill out an eviction prevention form. At the bottom right to the first page, I'm going to show you exactly what that is. You wait for a response. You submit once and only once. Ignore the error message. Please ignore the error message. If you don't get a response within 48 hours, come to Monday, Wednesday, or Friday at 6 p.m. So that I can figure out what's gone wrong. Other courts, go to stayhousedla.org. I'll show you how to do that right now. If you have a digital divide issue, you can use this number. Please note that this delays you getting help. There's a long wait list on that number. If you can, please just go on the websites. If you don't have a smartphone, you can get one at safelink.com. That's a government subsidized phone, so that, people cannot have a digital divide issue in a digital divide world. Saying that you don't have a smartphone is like saying you don't have a phone these days. You need to get a smartphone. You need to know how to use it. You need to have an email. You need to know how to use websites. Otherwise, you're going to miss out on a lot. So people need to suit up and buck up. I'm 62. I grew up in a world in which you sent a letter and 2 weeks later you got a response. Okay. The first time I used a fax machine, I put it in, the paper came back out. I thought it didn't work. Someone had to explain to me it was not a pneumonic tube. It got transmitted electronically. So I get digital divide. When we first got the ability to do electronic research, legal research, a young lawyer came in to teach me how to do research on the internet. And I said to her, I knew how to do research on the internet. She goes, you do? I said, yeah, I send you an email on the internet and you do the research for me. I've had to change that because I'm at home. My lawyers are at home. It's too hard for me to get people to do things for me. I refused to use Zoom pre-pandemic. I'm like, I'm sorry, I'm not learning this complicated thing. I would come to the office and people would put me on the Zoom. I learned how to use Zoom. If a 62-year-old can do it, anybody can do it. You need to learn, you need to buck up, you need to smart up, you need to suit up. Otherwise, you'll get left behind. It's a different thing if you're not literate, right? If you can't read or write, then a cell phone is a lot harder to use. So we want to save this for people with literacy issues who really do need to speak to someone because they can't maneuver the phone because they don't know how to read or write. There is this lockout number 213-340-4714 is for immediate lockout emergencies. It's answered 24 hours. At the beginning of the pandemic, it was an amazing resource. It rings into a cell phone. We would activate something called rapid response. 20 to 40 volunteers would show up at your place and either stop the landlord from locking you out or put you back into possession if you could prove you were a tenant there. The police would come, would intervene, and we'd save the housing. We were having like a 99% success rate with these lockout situations. In the last couple of weeks, I've had several lockouts that we've activated rapid response and not one single volunteer has answered. We don't know what to do about that. It's an unfunded mandate. We will never get funding for it because it's a relatively high risk action. It's going in there, getting in the landlord's face, stopping the lockout or putting someone back in. And so we're not going to get funding to do that. And we're not sure what to do. We need to motivate our base. These are all of the webinars. There are these are all the webinars that Eden does. There are many, many more on the Stay Housed LA website. So 6 p.m., 5 p.m., Saturday 1 p.m., the eviction process, which is the one that you are in, and the office hours. I'm going to put this presentation in the chat when I'm done. And now I'm just going to run through what the papers look like. But the truth is, if you get a piece of paper, you must immediately either go on edn.la or Stay Housed LA, and I'll show you how to do that in a minute. This is what a summons looks like. If you take your time to read this, it feels dense, right? It feels like, oh my God, what is all this? But if you read this, it says, you're being sued. You have 5 working days to file an answer. A letter or phone call will not protect you. You have to do it in a proper form. And here's some self-help center information. And there are other legal requirements. Get a lawyer, and it refers you to the self-help centers. The self-help centers are connected to Stay Housed LA. So if you get to a self-help center, you'll find out about Stay Housed LA, but you don't have to get to a self-help center because you already know about Stay Housed LA. And so I'm going to skip this, but basically it's what I've already explained. It gives power to the court over you. This is the notice of unlawful detainer action. This is a courtesy notice from the court letting you know that an eviction has been filed and that you should expect to be served. Our advice to you is that if you get one of these, just go to the court, get the summons and complaint, and answer rather than take a chance that the process server is going to lie and say that they served you. This is the prejudgment claim. If you are not named on the summons and complaint, you can get into the lawsuit by filling this out. We don't do it lightly. If you are a holdover tenant that's there without permission and you fill one of these out, you are saying, hey, me too, I want to be sued. I'm liable for this debt. You should not do that lightly. Now, if you have no other options, you have no place to go, then we might do that and then try to settle you out, but it is risky. Pre-pandemic, I would say maybe twice a year, we would bring someone into a lawsuit because it's that risky. During the pandemic, we've done it more because people can't find a place to go. So 5 days to answer. This is what the complaint looks like. It's the landlord's side of the story. This is what the answer looks like. It's your side of the story. Request for entry of default is what they submit if you don't file an answer. Many steps. At every step of the way, you can negotiate, as I've said before. There are motions, discovery, all kinds of things that happen. And the one motion that I want us to be cautious about is the motion for summary judgment. It can take 8 months or more to get even a losing case through the system. We have cases that were filed in 2019 that haven't gotten trials yet. The motion for summary judgment is reserved for cases where both sides agree on the facts of the case. You're just disagreeing on the law that applies. They're very hard to win, but every once in a while we'll have a case. I had, for instance, this year, a case where my client was accused of, I don't know, a whole bunch of nuisance allegations. That's usually triable issues of material fact. There is a dispute between the parties, but 2 of them were undisputed. And they did a motion for summary judgment and we couldn't dispute them. They had happened. We didn't think that they were the tenant's fault, but the tenant had not, it was somebody else, a domestic violence perpetrator that had done those two things. But the problem is that in order to use that as a defense, you have to get a restraining order, and the tenant had filed a restraining order but not pursued it. And so therefore, there really were no triable issues of material fact. And all of a sudden, we were in, we went from, we think we're going to lose, but we have some leverage to negotiate, and to we lost. And so we have to be cautious about the motion for summary judgment. And then we have to put together what are called trial documents, which are all things that the lawyers work on and need your help with. A little bit on post-judgment motions. If you lose, you're going to get this notice to vacate on the door. It is going to come with this writ of possession that says that the sheriff has a right to lock you out. At question 25, it says that if a prejudgment claim was not served with a complaint, then you can do a prejudgment claim now, or a claim of right to possession now. So it's a way to get a second start, a second bite at the apple, if someone didn't answer previously. Okay, but all of this is complicated, and what you really need is to talk to a lawyer. Once you're locked out, this will appear on your door. If you go in and this is on your door, it's a wobbler misdemeanor felony. We do not recommend that you do it. We do a lot of defending of unfair evictions. We work with tenants unions that will blockade the sheriff from executing on a notice to vacate. But this, breaking in after this is there is a very, very high risk action. We don't recommend it. There are 11 hub courts in the county that do evictions: West Covina, Pasadena, Compton, Long Beach, Norwalk, Mosque, which is downtown LA, Lancaster, Van Nuys, Chatsworth, Santa Monica, and Inglewood. We have divided up these courts amongst all of the agencies. As I've said, we cover West Covina, Pasadena, Compton for cases in the city of LA and downtown. Other members of the Right to Counsel Coalition cover the other courts. I'm going to skip Access LA and let you just read these fabulous slides, and then we are done. Again, I'm Elena Popp from the Eviction Defense Network. Kevin, can you stop recording? And then I'm going to